You're about to witness a former prosecutor systematically dismantle the FBI director's credibility in real time. Dan Goldman just cornered Kash Patel with one simple question about the Epstein files, and what followed wasn't just evasion. It was a masterclass in how power protects itself when the cameras are rolling and accountability comes knocking.
The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are. So your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims. But if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists...
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
you're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of
I'm
children
not asking
on the
about
internet.
that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the courts.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders work?
Actually,
Do you know how
Mr.
sealing
Patel,
orders
I was
work?
a real prosecutor for 10 years. I know exactly how
so I was a
court
fake
orders.
one?
And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless that
your
judge
testimony
waives
here
it.
is that all of those witness statements are under a court order A protective order.
We are providing everything we can legally provide.
No, that's not my question. My question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not under a protective
why
order?
are you not going to the court like you did for the grand jury testimony to unseal those records?
The DOJ did go to the court.
No, not on those records. Why aren't you going? You just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files, Mr. Patel.
Time of the gentleman has expired.
You are part of the cover-up.
Can I respond?
You sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false in the work of my
So I hope you will talk to them when they have requested to speak with you. Because the victims have requested and you are not responding to them.
What Dan Goldman accomplished wasn't just effective questioning, it was surgical exposure of institutional deflection when transparency threatens power. Goldman, leveraging his prosecutorial decade, methodically stripped away Patel's procedural excuses to reveal alarming patterns that extend far beyond this single exchange. The exchange began with a simple question about Trump's presence in Epstein files. Patel's claim he didn't hear clearly wasn't confusion, it was classic stalling, buying time to craft responses that sound responsive without being so. When pressed, Patel retreated to all credible information legally allowed, creating wiggle room for withholding virtually anything. Goldman demonstrated why prosecutorial experience matters in high-stakes hearings. He didn't accept vague court orders, but forced specificity about which legal barriers prevent releasing which materials. This precision questioning is what separates skilled prosecutors from typical politicians. Here Patel's evasion became obvious, conflating Rule 6e, grand jury secrecy, sealed orders, and protective orders into legal fog designed to discourage inquiry. Goldman knew better. Rule 6e protects grand jury proceedings, not all investigative materials. Protective orders don't automatically seal FBI files. Search warrant materials have different disclosure rules than witness statements. By conflating distinct frameworks, Patel was either ignorant or deliberately misleading Congress. The video discussion revealed problematic evasion. When Goldman asked about materials identifying other trafficking participants, Patel immediately pivoted child abuse material that obviously shouldn't be released, deflecting from Goldman's actual question about other perpetrators. This wasn't legal caution. It was strategic misdirection. Goldman's follow-up exposed the core issue. The FBI has discretion over releasing non-victim identifying information about other trafficking participants. Patel's claim everything relevant was used for prosecution dodges transparency obligations entirely. Prosecution decisions are separate from disclosure requirements to Congress. The witness statement discussion crystallized the problem. FBI 32 interview forms aren't subject to grand jury secrecy or automatic search warrant sealing. When Goldman pressed why these remain undisclosed, Patel offered vague protective order references without identifying which specific order prevents releasing which documents. This reveals a troubling pattern. Faced with specific legal questions, Patel offered general legal-sounding responses. When pressed for specificity, he became combative rather than clarifying. For an FBI director, this suggests either incompetence or intentional obfuscation. Goldman spotted something crucial. Patel kept insisting materials were sealed, unless something happened, but never completed that thought. In federal practice, sealed materials can be unsealed through court motions. If the FBI wanted transparency, they could seek judicial permission. Patel's responses suggested they haven't tried. The climax came when Goldman accused Patel of cover-up participation. Patel's defensive reaction, denying he'd protect traffickers, missed the point. Goldman wasn't accusing him of protecting traffickers, but of protecting powerful Epstein clients, a different cover-up with different institutional incentives. What emerges is troubling. The FBI appears using legitimate protections as shields for broader non-disclosure, conflating different standards to suggest tied hands when they have significant discretion. Most concerning, they seem unwilling to pursue judicial remedies enabling transparency. This isn't just about Epstein files, it's whether law enforcement can use procedural complexity avoiding accountability to Congress and public. When an FBI director can't explain which barriers prevent disclosing which materials, it suggests institutional incompetence or intentional opacity. Goldman's questioning exposed these dynamics through methodical legal analysis, not dramatic confrontation. That made it effective, and Patel's evasions revealing. In functioning democracy, agencies should explain limitations clearly and work toward maximum transparency. Patel's performance suggests neither commitment exists. The stakes couldn't be higher for institutional credibility.